Thanks to everyone for joining us. If you do have questions, feel free to type them in. And I believe Major Sawmiller is okay answering questions throughout. Is that correct?
I am, yes.
And we'll also save some time at the end. So without further ado, Lieutenant Colonel Select Jonathan Sawmiller, congratulations, is the Chief of Operations Law in the Office of the Staff Judge Advocate at United States Space Command. He holds a Juris Doctorate from the University of Idaho and an LL.M in Space, Cyber, and Telecommunications Law from the University of Nebraska, Lincoln. As a cyber operations attorney, Major Sawmiller was one of the legal advisors for the Russia Small Group Election Defense Initiative. And today, Major Sawmiller will be presenting his 2020 paper, Fighting Election Hackers and Trolls on Their Own Turf, Defending Forward in Cyberspace. So thank you for joining us, Major Sawmiller. Great to have you. And I'll turn the time over to you.
Well, thank you, Major Bradford, for that kind welcome. And thank you for the opportunity to present today. So the title of this talk and the title of the paper is Fighting Election Hackers and Trolls on Their Own Turf, Defending Forward in Cyberspace. And it is based on a paper I wrote in 2020, it was published in 2021. But I've included some updates for the current situation as it exists today. The necessary disclaimer at the front, the views that are presented both in the paper and in the talk are mine and do not necessarily represent the views of the Department of Defense or the United States Air Force, United States Space Command, United States Cyber Command, or any of its other components. And of course, the information has gone for a pre-publication review, it's unclassified, and is derived from publicly available sources. All right, so here's what we're going to walk through based on the outline of the paper. We'll talk a little bit about my background and the background for why this came about. We'll talk about Russian cyber activities in 2016 that posed kind of a new threat to U.S. elections that we hadn't dealt with before. And then we'll talk about the new response from the United States, which includes the Department of Defense's concept of defending forward in cyberspace. And then we'll look at the international law framework that DoD lawyers apply to analyze defend forward cyber operations, which includes the USAFA, the law and resort to the use of force, the customary international law rule against coercive intervention in domestic affairs, the concept of sovereignty, whether you view that as a principle or a rule, and then we'll talk about legal gray zones and retortion. And finally, we'll close out with a look at the future, what we see going forward in this realm. All right, so here's a link to the paper as published in the Idaho Law Review in 2021. And it's a project that grew out of some professional work that I did as a cyber operations attorney. I started out as a JAG in 2012, but I have a background doing IT admin, working in cybersecurity, web development. So technology is not a foreign territory for me coming in. The Air Force was kind enough in 2018 to send me to pick up a Master of Laws degree in Space and Cyber Law at the University of Nebraska in Lincoln. And then my follow-on assignment after the LL.M was to the Air Force component of U.S. Cyber Command, Cyber. The commander of that component is also dual-hatted as the commander of the Joint Force Headquarters Cyber Air Force, which is tasked with performing offensive cyberspace operations in support of multiple combatant commands. In that role, I was one of many legal advisors for the Russia Small Group Election Defense Initiative, which General Nakasone, the commander of Cyber Command, has publicly described as a joint USA, a joint NSA and Cyber Command effort at defending U.S. elections in 2018 midterms. I have a follow-on called the Election Security Group that worked for the 2020-22 elections as well. Currently, I'm assigned as Chief of Operations Law, U.S. Space Command out in Colorado Springs, where I still do some work in the cyber operations realm. As you might imagine, there are crossovers between cyberspace and satellite communication space operations. So the Air Force investment in the dual space and cyber LL.M is continuing to pay off in both of these operational positions that I've been employed in. You'll see up on this screen a shot from the Washington Post. U.S. Cyber Command operations approached internet access to Russian control factory the day of the 2018 midterms. About 2 years later, President Trump confirmed that was in fact States that the U.S. Cyber Command did, in fact, conduct offensive cyberspace operations against the Internet Research Agency, and that's been publicly disclosed by President Trump. All right, so starting out in 2016, we have a new threat to U.S. elections. And, you know, election influence operations, nothing new, going back to the founding of our country, but the means to execute it through cyberspace really came to the forefront in 2016 in a way that we hadn't seen before. One of the most notable operations by the Russian Federation was a hack and leak operation. So you had two different units of Russian military intelligence, the ERU, Unit 26165, sometimes known as Fancy Bear or APT-28. They accessed Democratic National Committee computers and Clinton campaign computers and networks without authorization. They gained initial access through spear phishing. Once they gained that, they moved laterally, escalated privileges, and then exfiltrated data. But the real impact came when they released that data publicly, and that was another Russian military intelligence unit, ERU Unit 74455, also known as Sandworm, titled a great book by an author named Andy Greenberg about the activities of this unit. I highly recommend that. If you want an unclassified look at what the Russians are doing in cyberspace, Sandworm is a fantastic book. But that unit released about 50,000 hacked documents that caused a lot of political consternation based upon the content of those, showing what the Democratic National Committee and Clinton campaign were doing sort of outside of the public view. So in addition to the hack and leak operation that the Russian government executed, you had overt propaganda coming from a couple of Russian mouthpieces that were identified later in an intelligence community assessment. Russia Today, now rebranded simply as RT, and Sputnik were probably the two largest. Structurally, they have some corporate governance, trying to separate them from the Russian government. But the IC assessment that was made public is that those are essentially extensions of the Russian government, and they engaged in, you know, the overt propaganda, trying to stir up conflict between political parties prior to the election. More concerning than overt propaganda, which is something the nation states have done from time immemorial, is the covert influence operation. The Department of Justice indicted a number of Russian nationals and 3 Russian companies, including the Internet Research Agency, for information warfare against the United States, engaged in through social media platforms. In 2016, the name Yevgeny Prigozhin may not have been familiar to a lot of Americans. The Russian oligarch who founded and funded the Internet Research Agency. Today, we're all familiar with him from his role in the Russian war against Ukraine as the head of the Wagner Private Military Corporation. Of course, he recently died under mysterious circumstances. But he was indicted along with the company that he led for covert influence operations in conflict through social media. And then finally, the IC assessment that they released publicly mentioned that there was activity from Russian Federation organizations accessing election infrastructure in the form of state board of elections, public-facing websites, and exfiltrating publicly personally identifiable information for about 500,000 voters. And IC assessed that there wasn't any actual manipulation of vote results, voter registration, nothing like that that would be construed as actual interference with the election. But there's concern that there was preparation for that based upon the access to this type of site. So what did the U.S. do in response to this? Well, we'll talk about some of the diplomatic responses later when we talk about retortion. But as far as the military role in it, Congress took a look at what was going on. In the fiscal year 2019 National Defense Authorization Act, Section 1642, Congress authorized the Secretary of Defense to conduct military defense of U.S. elections in cyberspace against named adversaries, including Russia, China, Iran, and North Korea. Around the same time, the president published a national cyber strategy that focused on U.S. efforts to defend elections. That was a key part of that. And then we have a classified U.S. cyber operations policy, NSPM 13, that was released with the DoD General Counsel and the Commander of Cyber Command, publicly described as a policy that allows some delegated authorities to the Secretary of Defense for timely cyberspace operations. That's about all I can say about that policy in this particular venue. But its release was significant. And then around the same time, the Department of Defense released its 2018 DoD cyber strategy. And included in that for the first time was the concept of defend forward. And we described it as DoD defending forward to disrupt or halt malicious cyber activity at its source. And that includes activity that falls below the level of armed conflict. So this is significant. This is the Department of Defense not just laying out doctrinally how it's going to fight during wartime, but below the level of armed conflict, in peacetime, malicious cyber activity, we're going to respond to it militarily at its source, means wherever it's coming from outside the United States. And in fact, we executed that strategy. And so there were joint Cybercom NSA cyber operations in conjunction with the FBI, the Department of Homeland Security, the Cybersecurity Security Infrastructure Agency, a whole government effort to defend not just the 2018 elections that followed 2016, but also the 2020 elections, the 2022 midterms. In all of these, there has been cyber operations, military cyber operations defending forward. What does that actually look like? D4M actions against adversary cyber infrastructure. All right, well, what is that acronym D4M? It comes from DoD doctrine. Doctrinally, JP 312, we have something called cyberspace attack, which we define as action taken in and through cyberspace that create denial effects. And there's three different categories of denial: degradation, disruption, or destruction, based upon the severity and the timing of the denial. Or manipulation effects, manipulation of data in cyberspace. We consider them a form of fires doctrinally, but as mentioned before, defend forward is not a strategy that's premised on wartime fires. It's a response to activities below the level of armed conflict. All right, so that's DoD doctrine. What does that look like in practice in the IT world? If any of you are familiar with a MITRE, a federally funded research and development corporation, they've developed what they call the attack matrix, which categorizes tactics, techniques, and procedures used by adversary advanced persistent threats against U.S. Government companies and other cyber infrastructure owners. So one of the techniques that the attack matrix describes is impact. After you've gained access, after you've done some privilege escalation, after you've managed to gain persistence to obfuscate your efforts, you actually want to have an impact on the system or network you're accessing. What are some of the techniques you could use for that? So MITRE describes it as trying to manipulate, interrupt, and destroy systems or data. And you see on the screen here the 13 different techniques that are currently in the attack matrix. I picked one of them as an example, and this is a subcategory of the disk wipe technique, disk content wipe, which is pretty much what it sounds like, right? Erasing the contents of storage devices on specific systems. You can do it in large numbers on a network, create a larger effect. You can do it in critical data on individual storage devices, but ultimately you interrupt availability of the system and network resources. If you're familiar with the CIA triad of cybersecurity, you're going after that availability piece of it. And the ways in which you can do this are numerous and varied. It doesn't have to require bespoke malware that you've written from scratch in binary. Right? This can be command line techniques used in an operating system. If you gain root in a Linux-based system, the old rm tac-f command, delete all in a directory, will execute this disk content wipe technique just fine. So there are a number of ways this can be done. So that's what defend forward looks like on the technical front. What's the legal framework for analyzing it that DoD applies? We start out with the idea that public international law writ large applies to state actions in cyberspace, just as it applies to state actions in other domains like the maritime, land, or air or space domains. That's been confirmed through the UN Governmental Group of Experts on Information and Communication Technologies process, the 2015 report that came out of that. The later 2021 report confirmed that. But it's relatively uncontroversial to say that public international law applies to state actions in cyberspace. What does that mean? If you look at the public international law, going back to the Lotus Principle, a famous 1920 arbitral case, states retain freedom of action to act in their own sovereign self-interest unless they agree to be bound by prohibited rules of international law. And how do they agree to be bound? Through international agreements, through customary international law that they engage in, right? And so the four areas that we're looking at the framework, the use ad bellum prohibition, the use of force, which is most prominently found in the United Nations Charter, an international agreement to which the U.S. is a party. We look at the customary international law, prohibition on coercive intervention. This is not arising from an international agreement, but from customary law, most prominently reflected in the 1986 ACJ decision in the Nicaragua case. We also look at the role that sovereignty may or may not play when we're assessing the legality of a cyber operation. And then how do we ultimately classify a defend forward operation if it doesn't rise to the level of use of force prohibited intervention? And that's where we're going to land the legal gray zones and coordinates. All right, so the use ad bellum prohibition on the use of force, UN Article 2.4, it prohibits the threat or use of force by states in international relations. What does that mean? Well, there's an unsubtle threshold of gravity in international law, right? How severe does an action have to be between one state against another before it rises to the level of use of force? You've got an attempt by the UN General Assembly to define aggression in a 1974 resolution. You've got some International Court of Justice cases. In the Corfu Channel case in 1949, it would appear that warships entering national waters to remove illegally laid mines, but not inflicting any damage on anything except for the mines, wouldn't constitute use of force. On the other hand, because the Nicaragua case, bombing and rocketing naval bases, airfields, ports, mining harbors, altogether, the court would say does equal use of force. Where a cyber operation somewhere in the middle of the spectrum, that's a unsubtle question, right? And different nations take different approaches when they're considering how this prohibition applies to cyber operations. The U.S. approach is to apply a physical effect framework. This was laid out very clearly by the DoD General Counsel, the Honorable Paul Nye in 2020 at the Cyber Command Legal Conference. I've got a quote up there on the slide from that. DoD lawyers considered whether the operation causes physical injury or damage. It would be considered a use of force that's called solely by traditional means, like a missile or a mine. So it's not the effector that we're concerned about, it's the effect. Does it cause physical injury or damage? And is that physical injury or damage significant enough that we would consider a use of force in the kinetic realm? You've got also the U.S. contribution to the 2021 UNGE report on responsible state activities in cyberspace. And that phrases it a bit differently, but it uses language that appears in the DoD Law War Manual and appeared in previous State Department Legal Advisor statements. Cyber activities that proximately result in death, injury, or significant destruction, or represent an imminent threat thereof, would likely be viewed as a use of force. We have flash armed attack in our DCE submission. The United States has a bit of a different approach when it comes to what the use of force means in international law than many states. In our view, any legal use of force against us authorizes a self-defense response under Article 51 of the UN Charter in the customary international law of the inherent right to self-defense. Other nations look more literally at Article 51 and think something needs to rise to the level of armed attack before you can respond to force and respond to use of force with your own force. So that is an ongoing disagreement between nations, if you will. The key here when we're looking at DoD operations is staying below the level of use of force, which, if anything, is below the level of an armed attack under international law. So we're looking at death, injury, or significant destruction. We got a couple examples in the DoD Law War Manual that are taken from a 2012 speech to the State Department Legal Advisor, LL.M. We would consider it most likely to be a use of force against us if a cyber operation triggered a nuclear plant meltdown in the U.S. or opened a dam above a populated area, flooded it with water, and caused destruction, death to people. Or a cyber operation that disabled air traffic control services and resulted in airplane crashes. Again, we don't care that this is ones and zeros that are causing this versus individuals with firearms or high explosives taking down the air traffic control services. The end result is the same. It's death from airplane crashes. Not all states look at this in a purely physical effect way, although most do. So in 2019, France published a official statement of their position on how international law applies to cyberspace operations. And they suggested that a cyber operation that caused widespread economic impact might be sufficient to constitute use of force, even if there were no physical effects. So there is different approaches by states, and this continues to develop. The UNGGE process and OEWG process has resulted in a number of states putting their views in writing on cyberspace operations and when they rise to the level of use of force. So if we apply the U.S. and Department of Defense approach to operations against hacking and influence operations by foreign actors, so if we're going against the logical network layer, the cyber persona layer, so not the hardware, not the metal, not the infrastructure, but the code and the logical processes, or the user accounts, or the social media accounts. And our primary effect that we're going to deploy, let's say, for example here, is a disk content wipe technique, wipe, one laid out in the MITRE attack matrix. And we're deleting data. Say from virtual storage, controlled by foreign social media influence operators. Because foreign operators are not necessarily going to, be posting their content on a server in their office in downtown St. Petersburg, right? They're making use of the global internet and these commercially available services to obfuscate their activities. But that's the primary effect. We're deleting data, right? All the information that goes into seasoning these social media profiles being wiped. The backups are being wiped. It's gone. They're going to have to recreate it from scratch. That's a primary effect. The secondary effect is that particular IT infrastructure can't be used for foreign social media influence on U.S. elections. They're going to have to reconstitute that infrastructure. They're going to have to purchase new VPSs. They're going to have to start recreating social media profiles. Have to recreate videos, recreate content. It's going to have an impact on their ultimate social media influence operation. That's not going to violate the prohibition of the use of force. There is no proximate causation of injury or death to persons. There's no damage or destruction to physical objects. This is solely data, information that is being affected through the primary effect. And the secondary effects are being controlled to the choice of target, right? This is infrastructure used for social media influence purposes. You could conceivably have a choice of target of an IT network, say a health provider IT network in a hospital with complete medical records, where deleting that data might actually result in death or injury to persons. So you control those secondary effects through your choice of target. Now, if you're applying this framework to operational technology infrastructure, OT, like industrial control systems, supervisory control, data acquisition systems, ICS data, that's going to look different, right? Because the purpose of those systems is to control physical things. And so your secondary effects very well might result in actual physical damage or destruction of the systems that are controlled by the operational technology network and target. So having concluded that an operation like this is not going to get use of force under the Charter of the LL.M, we move on to another prohibition on state conduct in cyberspace, the customary international law prohibition on coercive intervention. And this prohibits coercive intervention in the core internal functions of another state. The ICJ case in Nicaragua described it as the choice of political, economic, cultural system. It's a very narrow zone of matters that, as a matter of state sovereignty, states are allowed to decide freely. This is why we got the 1648 signing of the Peace of Westphalia graphic up here on the screen. This flows from the idea of Westphalian sovereignty. And that narrow zone of matters we refer to as the domain reserve. The precise contours of that, what's included, what's not included in the domain reserve, is a matter of debate. It's not well defined in customary international law. So customary international law is unwritten, right? It's state practice out of a sense of legal obligation. So you're looking at state practice to try and determine the boundaries of that zone. And there's a lot of debate among states about what's included or what's not. In addition to the intervention being in that domain reserve, it's got to be coercive, which means that the state who's being targeted be deprived of control over that. Mere influence or pressure isn't enough. It's got to be coercive intervention. And that element of coercion is laid out clearly in the ICJ case. So what exactly it takes to be coercive isn't well defined either. Use of force obviously is coercive, but because there's a separate prohibition on use of force, this obviously would include coercive means that are below the level of use of force. When we're looking at how states have applied this, there's sort of general agreement. It doesn't apply to things like espionage or propaganda, which the states have engaged in from time immemorial. But we do think the U.S. position is that it would apply and prohibit cyber operations by another state that interfere with another country's ability to hold an election or manipulate another country's election results. Note they said interfere with, not influence, right? Presumably we hope that our Voice of America propaganda broadcast in the United States might influence Russians to think a particular way when they're selecting their next government. That's not a violation of this customary international law rule. But interfering in a coercive manner with the ability to actually hold an election or manipulating the results would be. And so looking at our defend forward operations that are defending against election interference and influence, those state actors, they don't have a sovereign right to interfere with or influence elections in the United States. It's far from it. We have a sovereign right to conduct our elections free from their interference. And if we want to go after them because they're influencing, the principle doesn't prohibit that. So we laid out our position within the DoD at the DoD General Counsel 2020 address at the Cyber Command Conference. The 2023 address by the Honorable Caroline Kraft went into this further and explored some of the areas of debate and the kind of murky boundaries of this particular rule. What does it mean to be in the domain reserve? What are some of the state practices that's evolving in this? What are states currently saying about what they consider to be in the domain reserve? In 2021, as part of the U.S. CBD process, we included in our contribution that interference with the state's ability to deliver health care for the people might be a violation of this principle. The states have taken more expansive views of this. There's also a debate about the severity of coercion. How severe does it have to be before it's coercive? Is there an intent requirement? Do the intended consequences of the thing you're doing matter? Does it have to be as successful? Is just an attempt to coercively intervene enough to violate international law? Because if attempting it isn't enough and you have to actually complete the intervention, then you have basically different rules applying to states depending on how well equipped they are to defend themselves in cyberspace against these sorts of cyber operations. So there is certainly evolving views of how this customary international law rule applies to cyberspace operations. But under the U.S. view, it certainly does not prohibit defend forward operations that are targeting foreign actors trying to influence or interfere with U.S. elections. Another thing the DoD lawyers consider is sovereignty. And within international law, within the academic and state field, there's disagreement on how sovereignty applies to cyberspace operations. So you have advocates for sovereignty as a territorial rule, most prominently the authors of the Talent Manual, which is a non-governmental organization, a group of experts in academia that have come together to offer their opinions on how international law applies to cyber operations. It's not reflective of state positions or state practice, but it has been influential in the development of how international organizations and states look at cyber operations. And they posit that a cyber operation that causes consequence to manifest in cyber infrastructure that's located in other states would be a violation of a cyber-specific rule of territorial sovereignty. And that rule, they say, prohibits all non-consensual access to computers that are located in the territory. On the other hand, the advocates of sovereignty as a principle, United Kingdom is the most prominent example of this from a state perspective. They argue that sovereignty is a fundamental principle that undergirds specific rules that protect sovereign territory from foreign intrusion, but those rules develop through international agreements and state practice. There is not some free-floating rule of territorial sovereignty out there. And they point to the vastly different international law regimes that govern air, space, and maritime domains. And in the different domains, how sovereign territory is protected or not protected from non-consensual access. And of course, they point to espionage, which is not unlawful under international law, is widely practiced and involves, generally speaking, both remote and often in-person intrusions into territory. And so you have this ongoing debate, mostly in academia. There's also some states weighing in on it as well, with these two positions on sovereignty. The U.S. DoD position, DoD General Counsel laid out in that 2020 speech at the Cyber Legal Conference, and we take into account the principle of state sovereignty, not a rule. We study it and how state practice continues to evolve. We don't believe that there appears to exist a rule that all infringements on sovereignty in cyberspace are necessarily a violation of international law, which is sort of a nuanced way of saying that we understand the different positions. We don't view this as an impediment to non-consensual cyber operations. And as mentioned, the state positions do vary on this. So if a cyber operation isn't a use of force that's prohibited, and it's not a prohibited coercive intervention, and it's not an unlawful violation of a territorial rule of sovereignty, how is it classified in international law? Well, it really falls in gray zone, right? An area of state conduct that simply isn't regulated by international law. And activities in this realm can be classified as retortion, an unfriendly but not unlawful measure that states take in international relations, often in response to some other unfriendly acts by another state. So you see the headline up on the screen here: Obama expels 35 diplomats, imposes retaliatory sanctions in Russia for hacking. So expulsion of diplomatic personnel and economic sanctions are the emblematic examples of retortion, right? International law does not prohibit these activities. They're unfriendly, and they're often done in response to something unfriendly that another nation did to you, but they're not regulated or prohibited by international law. And that, in fact, was our response to the 2016 hacking, was retortion in the form of diplomatic activities and economic sanctions. The DoD view is for operations that are not a prohibited use of force or prohibited coercive intervention, that there is not customary international law that prohibits these non-consensual cyber operations, even if they manifest in the state's territory. It's simply not out there. And that widespread and consistent state practice that results from simple legal obligation might develop in the future, but doesn't exist today when it comes to offensive cyberspace operations. And based on that, the way we look at defend forward is that our commitment to defend forward, including a counter foreign cyber activity that targets the United States, that doing so comports with our obligations under international law and our commitment to rules-based international order. And so these are operations we can lawfully conduct and in effect do. So part of the article was looking at the future. I wrote it as part of the symposium on election. And I wrote it in spring of 2020. So I predicted more defend forward operations would be taking place by the Department of Defense and US Cybercom. And it turns out that has been the case. So in 2023, in March of 23, Bill Nakasone gave his positive statement for US Cyber Command to the Senate Armed Services Committee. And in it, he disclosed that foreign attempts to meddle in US elections via cyber means have persisted in every election cycle since 2016. So it was every there in 18 and 20 and 22. Most recently, in 2022, the US Cybercom and National Security Agency Election Security Group, in conjunction with the FBI and also the Department of Homeland Security, defended electoral processes and took action against foreign actors that were working to subvert the midterm. And in part due to these activities, the 2022 midterms went from primaries to certification of election results without significant foreign malign influence or interference. What happened in 2016 was not repeated in 2022. And Cyber Command expects that these attempts will continue. It's attractive to our adversaries, fairly low barrier to entry. So we expect that we're going to continue seeking to counter these, to render them inconsequential. Even though our adversaries are not going to give up, we're not going to give up defending forward. The other thing that we did a little bit of prediction on for the future in the article was the development of international law. The 2017 GDE on ICTs basically ended in failure without really reaching consensus. The 2021 iteration of this that kicked off in 2018, they did issue a final report, and we were able to reach consensus with 25 states that contributed experts to this, including the United States, Russia, China, the UK, all the major players in military cyberspace operations. But they reached consensus by not saying much. So they expounded on 11 voluntary norms of responsible behavior first identified in 2015 GDE report. Cool, voluntary, non-binding norms. These are things that responsible states do. They reaffirmed that international law prohibitions on the use of force and coercive intervention apply to cyber operations, but there was zero exposition on no details. Simply use of forces are prohibited by states in cyberspace. Cool. That doesn't help us much as a state or as a practitioner trying to apply those rules to military cyberspace operations. And states did submit their views on this, but ultimately it was too controversial to achieve consensus, and so those deeper explanations on international application were left out. Also didn't say much about sovereignty and whether or not a rule of sovereignty exists or a principle undergirding specific rules. It really says both, right? Like sovereignty and the principles and rules that flow from it apply in cyberspace, but no explanation of how. So we'll see how UN processes continue to evolve in this realm. There is an open-ended working group on information and communication technologies in the context of international security that is ongoing until 2025. They issued a report in 2021 and restarted. So the 2021 report really didn't address international law restrictions on cyberspace operations at all. In fact, that process was kind of fraught. So we'll see how these develop. More promising is individual states going on record, and as part of these processes and other processes, laying out their view of how international law applies to cyberspace operations, including cyberspace operations like defend forward that are taken in response to malicious cyber activities below the level of armed conflict. So it is it's an exciting area of international law to be working in, seeing how that develops, how state practice develops, and privileged to have been a part of the U.S. Activities in this realm. And with that, we'll move on to any questions, and of course the the obligatory cartoon to end the slide deck, right? Future war stories from Cyberwar is going to be fantastic, no doubt.
Okay, thank you, Major Sawmiller. So to our participants, if you would like to ask a question verbally, you can raise your hand. I can allow you to speak. If you would like to type in a question, I can share that with Major Sawmiller so he can answer it. So feel free to do that. In the meantime, I'll start us out just asking, how has the landscape changed in the past 3 years from a cyber and election standpoint?
Well, the legal landscape hasn't really changed. The same rules of international law that were in place in 2020 are still in place. You've had a bit more public discussion about how states view those, which is helpful, when you are analyzing activities and trying to align your activities with those of allies and partners, and understanding how they view these things is helpful. And so more states have gone on record publicly declaring their position on this. But the adversary activities haven't necessarily changed, and the DoD policy of defending forward hasn't.
All right. Since there aren't any questions yet, I was wondering, you talked about interfering with elections in light of the international law prohibition on coercive intervention. Do you see a difference in international law between, for example, hacking in and changing a vote tally versus pushing disinformation to manipulate voters' votes?
I do. And so the prohibition is on coercive intervention. So you're looking at deprivation of control. If you're hacking in and changing a vote tally, you are depriving your target state of their sovereign right to conduct an election, to choose their political system. You are forcibly doing that. You're taking that choice away from them. On the other hand, if you are simply providing information to their people in an attempt to change the way that people think through influence and persuasion, that's not coercive intervention. There's no deprivation of control there.
So to follow up on that, I don't know if I read it right or understood. Do you view this type of election hacking, whatever Russia was doing, as justifying a defend forward response? Or are you just saying that regardless, we can defend forward without having to justify it based on those kinds of Russian election interference?
So strictly speaking, the Russian activities in 2016, there was no coercive deprivation of control of U.S. elections. There was influence, which isn't prohibited under international law. It's an unfriendly thing to do, right? We don't like that the Russians are doing this, even if it's not technically prohibited as a use of force or a coercive intervention. And so we respond with retortion, with an unfriendly act that is also not prohibited under international law. So defend forward is one of our responses, one of our retortion responses. Diplomatic expulsions, diplomatic activities are another. Economic sanctions are another. All things that are properly categorized as retortion in an attempt to discourage future repetition of this unfriendly behavior.
So to kind of tie this all up, make sure I understand, defend forward, you say, is retortion so long as it doesn't rise to the level of a use of force on our
Correct.
end. All right.
Correct. And for the DOD, that rising to the level of the use of force requires physical damage and destruction, death or injury to persons. That's what we're looking at as a physical effect. Right? It would also not be retortion if it constituted a prohibited intervention into the domain reserve of the target state.
All right. We do have a question from Lieutenant Colonel Seth Dilworth. He says, thanks, Jonathan. Always learn a lot when you present things like this. It appears most responses have historically been State Department responses. Do you see a role for combatant commands aside from cybercom when it comes to election interference?
Yeah, it's really a question of policy, right? How does the United States government, U.S. writ large, intend to use its instruments of national power to respond to unfriendly activities by foreign states? And certainly combatant commands outside of cybercom have capabilities to conduct operations below the level of use of force of their own, whether those are military information support operations, or strategic communication, or other types of informational activities. If they're directed to do so and properly authorized by the executive branch, they certainly have capabilities they could bring to bear in this contest.
Okay, no other questions at the moment. I don't want to get nitpicky, but since there are no other questions, I remember having it. You wrote in the beginning of your paper, as this essay explains, defending forward is permissible under international law and essential to ensuring future U.S. elections are free from foreign interference. Do you see the possibility of future elections being actually free from foreign interference?
So interference, when it comes to actually depriving the U.S. of control of its own elections, is something that U.S. Cybercom essentially looked at the 2022 election and so we didn't really deal with. Free from foreign influence? No, I don't think elections will ever be free from foreign influence. We live in a free society where our people have the right to receive information from a variety of sources, including foreign sources. There's an interesting, I won't dive into it, but an interesting discussion about the First Amendment right to receive information and how it applies to cyberspace operations, sort of beyond the scope of this article or this discussion. But I don't see foreign influence on the U.S. people ever stopping, but foreign interference in our actual election processes and systems, I think that's something that cyber operations can effectively target, but we're going to have to do so routinely and persistently because there's going to be attempts every cycle out there.
All right. With still no further questions, what can you tell us about the Russia small group efforts?
Essentially what's been disclosed publicly by Cyber Command and the Department of Defense, which is that it was a joint Cyber Command National Security Agency initiative to defend the election. President Trump publicly disclosed that Cyber Command did in fact conduct offensive cyberspace operations delivering effects against the Russian Internet Research Agency in 2018. That's been confirmed. Probably about the extent of what I can go into there.
All right. Hey, we'll keep it open for another minute or two for any other questions. And then if there are none, I think we'll wrap it up. So any attendees, and I guess those of you on the phone, you can't really raise your hand. So I will allow you, if you would like, to dial in and ask a question. I think I've been able to do that with that button. So just a moment for anyone who may have final questions. Okay, and hearing none, I guess we'll wrap it up. Thank you very much. Interesting presentation and coming to the forefront again now that we're entering another election season. So thanks for your service, thanks for your work, and thanks for sharing this with us.
Well, thank you, Major Bradford, for the opportunity, and thanks to the Academy.
All right, you take care. Thanks everyone for attending. Hopefully we'll catch you next time.